Okay, this is the matter of People versus James Ball. It's on for sentencing today. My file reflects that James Ball previously entered a guilty plea to manslaughter in the second degree in violation of Penal Law Section 125.15, Subdivision 1, with an agreed upon sentence of no worse than an indeterminate sentence of 3 to 9 years, along with a waiver of appeal. I ordered the pre-sentence report. I have it. I reviewed it. I've also received a number of letters that have been submitted on behalf of Mr. Ball, on behalf of the Ross family. I read all of them, and I will make that part of today's record as well. Bill Fitzpatrick is here on behalf of the people, as is Hannah Renna, Emma Rossi, Michael Spano, Bob Duncanson are here, along with James Ball, the defendant. The people move sentencing.
We do, Your Honor.
Would you like to be heard today, Bill?
Yes, Judge. Judge, this is literally one of those instances where every lawyer in this courtroom would rather be somewhere else. And you can't help but go back to those events from 5 years ago and not play the what if game, if only. And I could go through them and
Mr. Fitzpatrick, pardon me for interrupting you. Feel free to take off your mask, Bill. It makes it easier for everyone.
Thank you, Judge. I appreciate that. As I was saying, you know, if only there hadn't been that beating, if only he hadn't gone and gotten the gun, if only he called 911. And I don't know that he disagrees with me on that. I'm sure the defendant has gone through that in his own mind. But that's academic now, because Christopher Ross is dead, and this family has been ruined, torn asunder. The relationship between the parties here, and I can't even imagine what the defendant's daughter is having to deal with, and she was forced to have to witness most of this the same. In any event, you know, oftentimes I stand here, Judge, and I'll ask you to look at the defendant's state of mind and the consequences of his actions. And when I talk about a defendant at sentencing, you know, this isn't a defendant where I'm going to stand in front of you and say, this is a bad guy. This is not a bad guy. This is a good guy. This is a teacher, father, husband. You know, he's not perfect. Nobody is that I know of in the last 2,000 years. And I know his counsel has worked hard to portray him in a positive light, and I'm not here to dispute any of that. But I believe the grand jury's decision was supported by the evidence, and that's what I'd like to focus on. And briefly, there's no question the defendant deserves some consideration, and I think the people have given him that. He's entitled to that because, as we know, of the brutal assault that occurred just before this homicide occurred. I don't know what they were arguing about. I don't care what they were arguing about. They're both adults, and that's why we took a plea that we did and agreed to cap the possible sentence at 3 to 9. So some of the things about that night, Judge, are not in dispute. First of all, this was a family that, for all his faults, they loved Christopher Ross. I don't have any history of angst between the defendant and his brother-in-law before that night. His wife, Lori, certainly loved her brother. There was a lot of drinking that day, an awful lot of drinking, and that made some of these things inevitable about bad judgment being employed later in the evening. As I said, the deceased and the defendant got into an argument. You've seen the pictures. The defendant got his butt kicked. It was brutal, savage, however you want to portray it. I'm sure Mike will do a better job than me. But after that, all right, sorry, Judge, totally speaking to the mic. At that point, things become a little more murky, but I think they're not indecipherable. Lori Ball, who clearly loved her husband and her brother, she does her best to de-escalate the situation and the violence. We all know that. And she apparently met with some initial success. The deceased is now outside with his sister. She's trying to get him home in a safe manner. Maybe as a compromise, he's going to sleep on the couch. Defendant is clearly upstairs. With all due respect to Lori, her version has changed what she initially told police from today. So I'm gonna leave that out of my description for the time being. Poor Allison, who I alluded to earlier, the defendant's daughter, she's then 16 years old. She's the niece of the deceased, and she's awakened by all this, and she sees what's going on. If there's more than one victim here, it's certainly Allison. She goes back upstairs and she does one of these FaceTime things with a friend, and then she sees her dad retrieve a gun, and she says something very telling for a 16-year-old. She looks at her father and says, "Dad, don't do this, you're gonna go to jail." She knows that. And I don't know whether it's alcohol or rage or a combination of the two. He ignores her, and then her Facebook friend overhears the defendant make a prediction that Christopher Ross is going to die. He then goes back downstairs, and here's why he deserves 3 to 9, Judge. 4 shots to the deceased. Now, I could suggest to you the order, but determining the order is, as we all know, we've all tried a lot of cases, it's pretty much impossible. But I'm gonna suggest to you that there is proof of what the last 2 shots were. So one shot is to the top of the left shoulder, and it's in a downward trajectory. Another shot is through his right bicep, and it travels across his body. And then what I believe are the final 2 shots. And these are clearly to the back. They enter below the right shoulder of the deceased, and they travel in a downward direction. And incidentally, Dr. Stoppinger said any one of the 4 could have been fatal. Why do I say the final 2? Number 1, Lori Ball has testified a number of times about this case, and she only heard 2 shots, and I believe her. Her brother was closer to her when the final 2 shots were fired. This is a .22 Ruger, doesn't make a lot of noise, it's more of a pop, pop kind of a sound. Number 2, the final 2 shots to the back, they're less than 2 inches apart. Now that suggests circumstantially, because this gun requires a trigger suppression for each shot, but it indicates very strongly, being less than 2 inches apart, that the deceased was immobile. It's not likely that this was the first shot, the second shot to the back, third shot over here, and then another shot to the back 2 inches from one. It's more likely that the deceased was immobilized when he was shot and stationary. Number 3, Dr. Stoppinger has testified that both of these wounds to the back, unlike the other 2 wounds, had stippling, indicating, don't forget the deceased had no shirt on, indicating that they were discharged from anywhere from 2 inches to 2 feet away. That was his testimony in the grand jury. And the 4th and final reason, Judge, that I believe those are the final 2 shots, are the defendant's own words. He gave a statement which was the source of litigation in front of Your Honor. He steadfastly denies shooting his brother-in-law in the back, and take him at his word during his interview. He doesn't believe that he shot him in the back, but clearly he did. There's no other shooters there. And twice in his videotaped interview, the defendant said something that had been bothering me, so in preparation for trial, I researched what the heck he was talking about. He made reference to learning the double tap technique from a book he had read in college in the early 80s about the Israelis and Mossad training. And this was involving somehow revenge for the Olympic athletes that had been murdered in Germany. And I found the book. The book is this, it's called Vengeance. And this is the reference that's made in Vengeance to the double tap technique. What the defendant must have made an impression on, 20, 30, 40 years later after he read it in college. Dave is apparently some expatriate American who was training Mossad agents, and he says, and if you pull the trigger, always pull it twice. If you were on target the first time, you'll miss with your second shot if you pause. And then continues, but if you pull the trigger twice, immediately, no matter what, there will be 2 bullets in the target if your aim was right in the first place. Then he continues, he says, but 2, always 2. Every time you pull the trigger, you pull it twice. And that's exactly what the defendant did. As horrible as it sounds, he fired twice, immobilized Mr. Ross, and then went over and executed him. And Judge, it's as simple as that. It's not because of his character. It's not because of the pain that this is going to cause the family in addition to what they've already suffered. It's what he deserves. And I really think 3 to 9 is a more than fair sentence for somebody that, executes his brother-in-law. And I thank you for the opportunity to be heard.
Thank you as well, Mr. Fitzpatrick. Mr. Spano, have you had the opportunity to review the pre-sentence report?
I have, Judge, and I've gone over it with Mr. Ball as well.
Very good. I'm sorry, let me microphone. And Michael, would you like to hear?
I would, Judge.
You can take off your mask as well, please.
Thank you, Judge. Judge, we're asking you to sentence Mr. Ball to probation today. We're asking you to impose a 5-year probationary sentence, Judge. And I believe it's appropriate in this case. I understand, Judge, especially after listening to Mr. Fitzpatrick, that you may have some reluctance in imposing that sentence. But it is an authorized sentence. The legislature has told us that for manslaughter in the 2nd degree, the crime for which he pled guilty to, the crime for which the people graciously allowed him to plead guilty to, and I thank them for that, Judge. This was their call to reduce this to manslaughter in the 2nd degree, based upon their review of all the facts and circumstances of this case. Judge, the legislature, by giving you that authority, is telling us that there are those cases, there are those homicide cases that warrant a probationary sentence. And again, Judge, I can understand your reluctance. There's a young man who tragically lost his life here. The Ross family has been suffering for 5 years, and I expect they will continue to suffer for a very, very long time, possibly the rest of their lives. But I'm asking you, Judge, to look at the history and character of Mr. Ball, which I believe you have quite a bit of proof about his history and character. And I'm asking you to conclude, Judge, that confinement is not necessary to protect the public, which is what CPL or Penal Law 65.00 says a judge should consider when considering a sentence of probation. Does this person need to be confined to protect the public? And I think the answer to that, Judge, is clearly no. And again, you've got a lot of information available to you. I'd like to start off by talking about remorse. I think there is just tons of proof in front of you that he has remorse for this. Judge, I've known him now for 5 years. Met with him numerous times. This has always been an important case to me. I've met with Mr. Ball quite a few times. And I can tell you for the first year, we could barely get through a meeting without him crying. And who is he crying for? Of course he's crying a bit for himself, okay? But he also cried for Chris Ross. He cried for Chris Ross's mother. He cried for his own daughters, his own wife. He knew what he had done. He took responsibility for it, Judge, when he came in here and he pled guilty to recklessly causing this death. So I think you have plenty of reason, Judge, to conclude that he is remorseful. You have all those character letters that I sent you, Judge. Remorse is in there. He has expressed his remorse to these other people over the last 5 years. You have a letter from his therapist, Judge, where she says that he has expressed his remorse to me. He has said, what should I have done differently on that early morning hours of July 4th, excuse me. What could I have done differently so that this wouldn't have happened? He's learned from it. He's learned from that remorse, Judge. And I'd ask you to take that into consideration. But what else do you have in front of you to let you know about his character, his history and character? You've got all of these letters from these people that know him best, Judge. And who are these letters from? They're really from all different stages of his life. What you have in front of you with those letters, Judge, is you have his life story. It starts out with his brother and sisters talking about him as a child, how he was as a child. He was a happy-go-lucky kid, always wanted to have fun. had a lot of friends. Talked about the household he grew up in. A single mother who was an alcoholic, how difficult that was. So you've got him as a child, Judge. And then we pick up with his childhood friends. We've got a letter in there from someone that's known him for 48 years. I believe they were 11 or 12 when they met. They started throwing snowballs at each other from across the street, and they became friends ever since. And that person has been his good friend for 48 years. And that tells you something about a person, Judge, that they're able to make and retain friends throughout their life. We pick him up again with his high school friends, Judge. There's letters in there from his high school friends. And they tell you that, with somewhat pride, one person writes, he was the only one in our group that went to college. After high school, he went to college. And then we pick up his life again through these letters, Judge, with his Navy buddies. Some of them are here today, traveled from Kentucky, traveled from Virginia to be here today, to show their support for Jim Ball. We have these letters from his Navy friends. They have been lifelong friends. Some of them say, after I got out of the Navy, we continued this relationship. I've met his kids, he's met my kids. He's even helped some of my kids with their college decisions and life decisions. After the Navy, Judge, he gets married. And we have letters from his neighbors from when he first got married. There's a beautiful letter in there from one of his neighbors that says how delighted she was when this young family moved in. And I could see the love between Lori and Jim Ball. And then it was so nice to see when they had these two girls and watch them grow up. Watch Jim Ball outside playing catch with his daughter. She talks about seeing Jim Ball on prom night, walking down the street, so proud of his daughters in their prom dresses. You know, Judge, that letter right there tells you a lot. Just this neighbor looking in on this household. That tells you about the character and history of Jim Ball. And then, Judge, we have letters from his workplace. We have letters from his colleagues. He after the Navy, he worked for a while with TSA. From there, he went back to college to get his master's degree in education at Lemoyne. Did that while he had children. Did that while he was married. Worked hard, and got his degree and became a teacher. You have letters from his colleagues, the teachers that he worked with. You have letters from parents. You have letters from students written in crayon, Judge, thanking him for the job that they have done. Several of these character reference letters mention how when I would meet people and they would find out that Jim Ball was my brother, and they would tell me about how he taught their children. Judge, that very thing happened to me. There's a young woman that works in another court in another county, and she found out that I represented Jim Ball, and she said, tell him I'm in his corner. Tell him that a lot of the mothers that are aware of what he's going through are in his corner. He was so good to my son. And her son was much older now, Judge. So I've experienced that myself. And then we have letters, Judge, from his wife. So you have every part of his life is documented for you about his character and his history as a human being, Judge. And his wife describes the kind of husband he is, the kind of father he is. And then finally, Judge, you pick it up with probably the most important thing he's ever done with his life, and that's raise his two daughters. And you have a beautiful letter from them describing what he has meant to them. And you know something else, Judge, that I think is important? This case has been going on for 5 years. I know you've read the grand jury minutes. I know that you know that at one point there's talk about planning their daughter's high school graduation party. And that was going on at the time this happened. They were planning that party. They had some of the items for that party there. Well, this young lady's in the courtroom today, Judge. She's a college graduate. She has a job. She's going to go back to school and possibly become a teacher also. His other daughter is a junior in college now, Allie, the one that unfortunately witnessed these events. She finished high school, graduated, or is now a junior in college. Judge, that in and of itself says something about Jim Ball. You've been doing this a long time. I've been doing it a long time now too. And you know firsthand the stress involved in having a criminal case hanging over your head. This case has been hanging over his head for 5 years, and all the stress that comes along with that. And he's done his best, Judge, so that these girls don't miss a beat with their lives. They just keep going. And I think that says a lot about Jim Ball also, Judge. I think when you look at all of the circumstances surrounding this case, and you look at the character references, Judge, that I've submitted to you, I think a sentence of probation is appropriate in this case. Jim Ball is not a threat to this community. I don't believe he is, and I think Mr. Fitzpatrick would tell us that he agrees that Mr. Ball is not a threat to this community. And I think that probation, Judge, would be an appropriate sentence in this case. Lastly, I just want to mention, I'm not really prepared, Judge, to talk about the facts of this case today. I know that Mr. Fitzpatrick got into it, but we pled guilty. We've accepted responsibility. So I don't really want to get into the facts too much. But you know this was a self-defense case. You know it very well. You've read 2 sets of grand jury minutes on this. We've argued up at that bench about self-defense. And I can remember one time slamming my hand on that bench because I was upset about something. So we've argued very, very strenuously about self-defense. Judge, as you know, of the three of us, Mr. Fitzpatrick, you and me, I'm sort of the baby here. I've only been practicing for 30 years. You've been practicing longer than me. Mr. Fitzpatrick's been practicing longer than that. We all know when these things happen, Judge, it's a body in motion. It's 2 bodies in motion. It's the person firing the gun and the person being fired at. They're both moving. I have no idea, Judge, which shot was fired first. I have no idea what position Mr. Ross was when he was struck. And it could appear as though he was struck in the back. We were prepared to show a different side of that, Judge, and that people were moving, people were twisting as those shots were being fired, and that accounts for those shots in the back. Judge, I started out by asking you to sentence him to probation, and I want to finish with that, Judge. I think it's an appropriate sentence. I would ask that you sentence him to probation today. I know that Mr. Ball has a few words that he'd like to say also.
Mr. Spano, thank you. Mr. Ball, would you like to be heard? Please, yes. It makes it easier for all of us.
On July 4th, 2017, in our home, there was chaos, some violence, and above all, a tragedy. For the last 5 years, we have all been wrestling with the question of culpability on the one hand and mitigation on the other. Mr. Spano and Mr. Fitzpatrick, to their credit, have come to the conclusion that the ultimate decision in this case must be made here, this afternoon, by this court, under the conditions that they have agreed with the court to be implemented. I say in all sincerity that I have seen how hard they work and I respect their efforts. Again, Judge, that was a morning of incredible chaos, but in the most general terms, there were a few very serious physical confrontations in the house. There was a period of time when my wife, Lori, and my brother-in-law, Chris, went outside to see if things would cool down and she could drive Chris home. During that period, I was trying to make preparations for what might happen next. There came a time when Chris came back into the house with Lori, trying to hold him back, and it was at that time when I shot Chris. When I appeared in front of the court in December, I told the court that I acted unreasonably and I was responsible for Chris's death. My conscientious belief is that the responsibility lies with me because I should have used that time to contact the police. The police should have been called to my house before Chris was shot and not after, and that is the basis of my guilt, and that is what I live with day in and day out. People often say in the aftermath of a tragedy that they are going to live with that tragedy for the rest of their lives. I live every minute of my life in regret and guilt. Regret and guilt that Chris lost his life under these circumstances. Regret and guilt and the impact of this tragedy on the Ross family. Excuse me. Regret and guilt that Lori lives every minute of her life recalling standing between her brother on the one hand and me on the other. Regret and guilt as my 2 daughters are beginning to they do so with this awful memory that will never leave them. I will not spend another day of my life without looking for a way that delivers some relief and some sense of the overwhelming grief that I feel to all those involved, including Lori and the girls and the entire Ross family. Thank you.
Thank you, Judge.
You can sit down. Well, all 3 of you have given me a great deal to think about. I have been thinking about this case for a long, long period of time. It is perhaps the most difficult sentencing decision that I've had to make while being here, quite honestly. There's no sentence that can be imposed today that will make everyone happy. It's certainly clear to me. This is a tragedy of immense proportions that cannot be undone by whatever sentence I impose today. I've reviewed the pre-sentence report, and the mitigation materials have been submitted by the defense, and there's clearly a major divide between the Ross and the Ball families as to the issues of responsibility and what is an appropriate punishment. There are countless victims of what happened on the 4th of July 2017 in your home in those early morning hours. Victims, in my opinion, are not limited to Christopher Ross and or James Ball. Many folks have suffered and continue to, and I can sense that here in the courtroom today. That's not lost on this court. Lives have been changed forever, and family dynamics have been torn apart. Simply stated, however, it's beyond my power to put this back together. I wish I could. I can't. I think the attorneys have done their best to find some measure of fairness and justice. I hope that it's not lost on anyone that a grand jury has returned an indictment twice, charging you with murder in the second degree, where the minimum sentence was 15 years to life, and the maximum sentence was 25 years to life. With the possibility, as a 60-year-old man, you may well have died in prison while awaiting your release date if you were convicted of murder at trial. Only through the exercise of sound discretion by Mr. Fitzpatrick and the excellent representation by all of your attorneys are we even having this sentencing discussion today. I hope everyone realizes, and I believe you do, Mr. Ball, how unusual this plea was, as is the sentence to be imposed. I hope you realize that many of your positive attributes and the circumstances of the 4th of July have already been considered in reaching this unique disposition of a plea to manslaughter in the second degree to satisfy a murder indictment. During your lifetime, Mr. Ball, you've cut a fine path for yourself and your family. You've served your country, received an honorable discharge from the United States Navy. You've served your community. You're a very well-regarded, now retired school teacher and youth coach. You've been a source of comfort and respect for your family, who quite clearly remain loyal to you. You're held in very high regard by friends, by fellow teachers, by your neighbors, by students. There's no question about that either. I have absolutely no doubt that you are remorseful, no doubt. This is a sad and a unique situation. It's taken an emotional toll on everyone over the past few years as this matter went through the appeals process and then through COVID delays. But a person's dead, and his possibilities are gone. And you can't give that back no matter how sincerely you want to. Your possibilities remain. And that is not true for Christopher Ross. No matter how many positive things you've accomplished a lot. I can't overlook that a person is dead. You clearly were under extreme duress that morning. And as we all know, alcohol and guns are never a good combination. There were alternatives available, which you now acknowledge. Unfortunately and tragically, those alternatives were not used. And what appears to the court to be left is two devastated and divided families, left only with pain and grief in common, with no easy repair in sight. I'm sorry for everyone's loss. And Mr. Fitzpatrick was right when he initially said, none of us want to be here today. None of us. Taking all these unique circumstances into account, as a result of your plea of guilty to manslaughter in the second degree, The sentence is that of an indeterminate sentence of imprisonment of 2 to 6 years. The minimum is 2, the maximum is 6. There was a waiver of appeal at the time your client entered this plea. Is he reaffirming that waiver here in court this afternoon? Is he reaffirming that waiver, Mr. Stanton?
Yes, sir.
There's a point surcharge of jail.
Extended deployment. You're on extended deployment, man.
I love you.